Yes,
For pronouncement of judgment and order, item number 15 to 17.
that keep it. We'll pass it subsequently. I'll dictate it here only. Yes.
I beg to mention item number 31. I just filed my Bakalat number this morning, my lord. So when we sometime.
You are for the respondent number
Respondent number
5. And government?
No, sir. I understand.
No affidavit has been filed. You are accepting that plea that it was only in the notice board, not in the newspaper. If that be so, we'll close it. Go ahead with a fresh one.
That is not going to change.
That's what do you say? Where did you get it? You only had access.
The petitioner has not placed anything on the court to show that he is eligible to even bid.
Okay, fine. We'll come to that. But how did you get the bid in the first place? That cannot be. It's already decided by this court.
Yes, ma'am.
And that's the law.
So kindly give me some time.
Okay. 31. On the prayer of the learned counsel for the respondents, the
I
matter.
also filed affidavit of service.
It's come. And they write like this. The Mr.
Yes, okay, ma'am.
S. Kohima, learned counsel for the has entered appearance for respond number 5. Accordingly, the service of notice upon respond number 5 is complete. Para. The learned counsel for the learned senior government advocate as well as the learned counsel for the respond number 5 has prayed that they be granted further 2 weeks time to bring 3 weeks time to bring on record their stand by way of filing affidavits. Prayer accepted. Registry to list this matter again after 2 weeks on a date to be fixed by it. The interim order passed earlier to 3 weeks. 3 weeks, huh? The interim order. Absolute. Okay, fine.
That is your lordship. Lordship, I take to mention hearing item 14 also. Lordship, where
Mr.
I've already responded.
You are making this prayer on behalf of Mr. Zimomi. No.
No, lordship. For respondent number 4, lordship.
Who is the counsel?
Senior Ajo.
Zo. A prayer is made on behalf of the learned counsel of Mr. Azo, learned counsel for the respondent number 4 for an adjournment in the matter on account of personal inconvenience. Prayer is not objected to by the learned counsel for the petitioners. Full stop. Accordingly, registry to list this matter again after.
First of June, lordship.
List this matter again on 1/6/2026.
Which be interim order.
Interim order passed earlier to continue till the next date of listing. Dutta, Respond number 4 in both the cases.
Lordship. Much better. Lordship.
My appreciate lordship. Lordship, I beg to mention hearing item number 12 on behalf of Nagaland. Since this in this was kindly disseminated after 1 week.
Indisposed.
Yes.
A prayer is made on behalf of Ms. N. Longkume, learned counsel for the petitioner for an adjournment on the ground that she is indisposed. Prayer is not objected to by the learned counsel for the respondents. Accordingly, registry to list this matter again. When? On 28/5/2026. Done? 28/5.
For motion from the supplementary cost list, item number 18.
Your lordship. During the construction of the 2-lane road project from Gauhati to
Any joint verification done till now?
Yes, your lordship.
Who has with the NHIDCL authorities? No, this is a report by the Deputy Commissioner. Who is for NHIDCL? Anybody appearing? There is no standing counsel NHIDCL. Madam, we issue a notice now on the returnable. You are for NHIDC. Get why this? There is already a report of the deputy commissioner. What have you done after that? A notice I will issue, but get this thing done. Citizen is before this court, damage to her land. Maybe you, maybe your contractor, but you are responsible. Her, madam, your name?
B.
Abhi, learned counsel for the petitioner. Also heard Mr. Who is for the Union of India?
Yes, Lordship appeared on behalf of my senior, young lawyer,
Mr. Your name?
Mr.
Mr. Salazo, learned counsel, appearing on behalf of standing counsel, Mr. Yanganavati, learned CGC. Also heard Mr. Mozami, learned counsel, standing counsel, NHIDCL. And Mr. M. Longkumar, learned state counsel. The petitioner, by way of petitioner in the present proceedings, has raised a grievance with regard to the inaction on the part of the respondent authorities in duly compensating her with regard to the damage occasioned to her property on account of construction of the two-lane Kohima to Jasami Road by the NHIDCL authorities. Full stop. Issue notice returnable 4 weeks. Mr. CGC, Namgita Likhirivi, accepts notice on behalf of respondent number 1, while Mr. So-and-so, learned standing counsel, NHIDCL, accepts notice on behalf of respondent number 2. Mr. For chief engineer and chief engineer also you will accept?
Yes, 3, 4, 5, and 6.
3, 4, 5, and 6, government advocate. No formal notice, Likhirivi. Petitioner to take steps for service of notice upon the respondent number 7 by way of speed post. Want to do Dasti, will not be able to do Dasti. Speed post, okay. Steps within 2 working days from today. Registry to list this matter again after 4 weeks. The respondents. For pendency of the present writ petition shall not be a bar for the respondents to redress the grievance of the petitioner in the present proceedings.
For admission, item number 1.
Please, Lordship, I have one instruction. So this may be listed on theatre tomorrow.
Why?
Because I had a telephonic call yesterday. On this case, we want to discuss something tomorrow. So the matter will be listed on Thursday. And this will be a very with certain condition. Otherwise,
Mr. Imsam, there is no problem in adjourning the matter. But your stand in the affidavit is that you have now made a draft rules. That is a draft rule of recent origin. Now this draft rule till now you have not finalized, and your statement is qualified that it is in the legislative process. So that has not seen the light. So as it stands, the rules of 1998, I'm sure it's 1998, therein there is a clear-cut distinction between employment and the craftsman.
Yes.
So the person who has now crossed over is from the craftsman area. He cannot cross over.
The rule 3 says there are 2 posts of the director.
No, see, the rule, your affidavit is to the extent that there is a post of joint director created for looking after the craftsman thing, but it is not incorporated in the rules. It's an ex-cadre post. But your post that now you are holding is the post which forms the cadre of the employment wing.
That's fact. Now the post that was created, the joint director, and the joint director is the post of the craftsman.
Now, who is the person who was promoted with the creation of that post? With the creation of that post, there was someone promoted. Mr. Amel,
The employment wing to the director. Fine.
No, just a moment. Let's come to your affidavit. Therein you have made a statement, you have made that order is on record. Can you just take me to that order? That creation order. Page 16. Who is Alam Longkumer? He is from the employment or from
Employment. Will show the chart at the time of document.
I think I have argued your matter. He is from the employment wing.
The government will also has.
Fine. Maybe, but on the date it was created, it was utilized by the employment wing. You approached this court by way of assailing that rules.
Yes, the deputy director post of government was upgraded to join that.
But see, the person who was upgraded belonged.
The person concerned is one aspect of the matter.
But then how were you promoted? There was only one post of deputy director. You were promoted subsequently from where were you accommodated?
This matter is not being able to take up today.
On the prayer of the learned counsel, Mr. I. Imsok, learned additional advocate general appearing for the state respondents, stands adjourned. Registry to list this matter again on 26/5/2026.
It can be as item 1.
Okay, come.
One.
Item number 2.
Yes, who is appearing for this central government? You are appearing. You are appearing.
Insurance.
No, central government. Mr. Counsel, are you appearing for the central government?
Yes, sir. The ministry and the government. I know this is someone.
I see.
I'm done with it. So I leave it to you. If there's no response from the ministry, I leave it to you.
What do you say, ma'am? Huh? Not much to say. You have done your work. Because I pass an order that will remain unimplemented here, then there will be an appeal saying that they were not heard, then the man would again be put to trouble. Okay. Your name? Mr. Yangarwati, learned CGC, appearing for the respondent number 1, has very fairly submitted that he had taken up the matter with the respondent number 1 on several occasions. However, he is yet to receive any instructions in the matter. From the materials brought on record, it is seen that the proposal with regard to release of the due compensation to the petitioner on account of the death of his brother, who was a frontline worker, is presently pending with the central government in the Ministry of Health and Family Welfare. The Secretary to the Ministry of Health and Family Welfare is hereby required to place on record the status of processing of the claim of the petitioner by the next date of listing through Mr. Yangarwati, learned CGC. In the event the instructions are not so furnished to Mr. Yangarwati by the next date of listing, this court would be left with no other alternative but to require the personal presence of the Secretary, Ministry of Health and Family Welfare before this court on a date to be so fixed for the purpose. Mr. Yangarwati is requested to download a copy of the present order and forward the same to the Secretary, Ministry of Health and Family Welfare, New Delhi, Government of India, New Delhi, for compliance. Registry to list this matter again on 16/6/2026. 16/6/2026. You please have your word with him.
Sorry for the indulgence. Lordship, my additional would be, as mentioned, day after tomorrow. Item 1.
Day after tomorrow, because see, I'll be leaving on Friday. So today it was fine with me, because if I have to dictate, I don't want to keep it back. That's why I kept it on 25th, 26th.
Can it be tomorrow, man?
Let it be on 26th. Because thing is, Mr. Counsel, I hear it today, tomorrow I can dictate. But Friday again, I'll have to go. It will be troublesome for all.
Item number 3.
Yes.
Here is also, in compliance with order, there is activities that have my affidavit, in the front hall. I have to copy to the status.
You have filed it today.
This one.
Today. The learned counsel for the petitioner submits that a rejoinder to the affidavit filed by the respondent. The state respondents has been filed today. Also, accordingly, registry to list this matter again on 1/6/2026 along with the said affidavit in reply filed by the petitioner.
Item number 4.
This lordship, my lord, I'm referring for response number 5, 6, and 7. My lord, I'm yet to receive instruction reply. I'll make sure this time. My lord,
The Assam Rifles have filed an affidavit.
yes,
So why can't you file an affidavit? You file a rejoinder to that affidavit. Then we'll proceed. State wants to file, otherwise. The learned government advocate appearing for the respond number 5, 6, and 7 submits that he be given a last chance to file an affidavit on behalf of the said respondents. The respondents number 3 and 4, 1 to 4 have already filed their affidavit, and the learned counsel for the petitioners prays that he be given further 2 weeks time, 3 weeks time to bring on record a rejoinder to the said affidavit on behalf of the petitioners. Prayers accepted. Registry to list this matter again after 3 weeks on a date to be fixed by the next date of listing. The pleadings be completed by the respective parties.
Item number 5.
Lordship, the affidavit is ready. I'm waiting for the signature of this.
Okay, Mr. Yangarvati, Lanat CGC appearing for the respondents number 1, 2, 3, and 4 submits that the affidavit on behalf of the said respondents would be filed within 2 weeks from today. The respondents number 5, 6, and 7 have already filed their affidavit in the matter, and the learned counsel for the petitioner prays that he be given 2 weeks time, 3 weeks time to file his rejoinder thereto. Prayers accepted. Registry to list this matter again after 3 weeks. The parties to complete their pleadings by the next date of listing.
Item number 6.
Yes, Mr. Verma. You have not. You're muted.
Yes, my lord.
Your affidavit reply is not on record.
Yes, my lord. There is some difficulty because I could not send it. I was given 3 weeks time. That apart, my lord, the central government counter is necessary in this matter, and this was posted for that also. I could have proceeded with without reply also in this matter, but
State has already filed its reply.
State has filed, my lord. I'm looking. We are waiting for the counter of the central government. Because my case is that I have paid the central government taxes.
Central government, the state government, now you want to recover.
State
Yes.
government wants to recover. That cannot be done. Either is the state or the central. I can't be penalized, I mean, to.
Yes, Mr. Yanarbati, are you appearing in this matter for the government?
It's actually coming up for the counter of the central government, ma'am.
Five, 6, and 7.
The customs we have, they have the customs, they have this study passport.
Okay.
So,
Mr. P.B. Verma, learned counsel for the petitioner, submits that the rejoinder to the affidavit filed by the respondents number 1, 2, 3, and 4 would be filed within 2 weeks,
Within
3
1
weeks,
week, madam. Within 1 week from.
within a week from today. So, there is no representation on behalf of the respondents number 5 and 6. 5, 6, and 7. Further, no affidavit has been brought on record. For the ends of justice, a last chance is granted to the respondents number 5, 6, and 7 to bring on record their respective stand by way of filing an affidavit. No further adjournment shall be granted for the purpose to the said respondents. Accordingly, a registry to list this matter again after 3 weeks on a date, 3 weeks on a date to be fixed by the parties to complete their pleadings by the next date of listing. Give it 4 weeks. 4 weeks to complete pleadings.
Obliged.
For admission from the supplementary cost list, item numbers 19 to 30.
Yes.
Worship, I have certificates of time on behalf of the area administrator.
That last order was very specific.
Yes, Lord. There's a last test, worship, I have a single email that I need to see some more time.
Now, you have admitted to that their lands have been taken over. So the next thing would be the proceedings under the act. That's all.
I've given it to your worship.
Have you transmitted a copy of this order?
Yes.
Still no response.
We have over the but said to take us to a long time. Worship.
Mr. Yanarbati, learned CGC appearing for the respondents number 1 to 4, right? Submits that in terms of the directions passed by this court while the order dated 28/4/2026, he had communicated the order to the respondents represented by him. And in response thereto, the respondents have prayed for further 2 weeks time, right? 2 weeks will do?
So that's just about 3 weeks.
3 weeks?
We have accounts that, since we have accounts.
3 weeks time, 3 weeks time to file a rejoinder, file an affidavit in the matter. Prayer is objected to by the learned counsel for the petitioner. However, for the ends of justice, a last chance is granted to the respondents number 1 to 4 to bring on record their stand by way of filing an affidavit. No further adjournment shall be granted in the matter to the said respondents. Registry to list this matter again on 11/6/2026.
For orders, item number 6, 7.
Resolution.
My lordship will produce the last 2 orders.
Where is your amended cost title?
But this matter involves so many all documents, so we are facing some problem. Now the government has indicated need to seek some more time. Of course, we have taken a sufficient time. Last year, some more documents could not be traced out on.
You've not filed some petitioners were deleted.
What sheet? The cost title?
Cost title. I think some petitioners were deleted. Just
Yes.
give me the have you brought on record after that deletion, have you corrected the cost title? No,
It was it was them who filed it, not me.
no, but still you have to file the amended cost title because it's your petition.
That was filed by other.
They were petitioners. So you have to bring it on record because 1, 2, 3, 4, 5, 6, 7 petitioners had got their names deleted. Petitioners number 2, 3, 12, 14, 24, 31. You go through the order dated one. No, you can go through these orders. It's there. After free time, you can go through those orders. Now, some of the private respondents have filed their affidavit. Have you filed a rejoinder there too?
No, I'm waiting for the state respondents to file their affidavit.
No, state is in much, you have put them in much trouble. They don't have anything.
Yeah, chief. How can a person be given seniority prior to his or her appointment? That is the only issue here and the question of law. Lord Chief, why they are taking now, it's 9 months. I filed this writ petition on, it came up for motion on 21/8/2025. 25. No, 25. It's now already 9 months, going to be 10.
Mr. I, in some learned additional advocate general, by placing on record a communication received by him from the school education department, has prayed for further time to file an affidavit. So this court-wide order dated 7/4/2026 had granted to the respondents a last chance to bring on record their stand by state respondents to bring on record their stand by way of filing an affidavit. This court-wide order dated 5/5/2026, considering the submissions made by the learned advocate general, submissions made by the learned advocate general that the official who was to file the affidavit was on leave, had granted further adjournment till today. Even today, the affidavit is not on record. Considering the orders passed by this court on 7/4/2026 and 5/5/2026, this court is of the considered view that the adjournment, if any, granted to the respondents can be so granted only with a cost imposed for the purpose. Accordingly, while adjourning the matter for further 2 weeks, this court directs that the state respondents, more particularly the respondents in the school education department, shall deposit an amount of rupees 2,500 with the registry of this court. The amount on being deposited shall be transferred to the account of the, what is your bar association here?
No bar association.
Kohima.
High Court Bar Association.
High Court to the High Court Bar Association, Kohima, for utilization of the same in its activities.
3 weeks as of last.
3 weeks, 3 weeks, 3 weeks, 2,500, 3 weeks. The amount be deposited within a week from today. In the event the affidavit is not so filed by the next date of listing, the Secretary, Department of School Education, along with the concerned directors, Where is the respondents, list of respondents here? Got it. Along with the first Principal Director, Department of School Education, Nagaland, and the Director, Department of School Education, Nagaland, shall remain present before this court on the next date of listing with the contemporaneous records to assist this court towards disposal of the present petition. Registry to list this matter again on 11/6/2026. If they can't come, if they can't file, ask them to come with the records, we will interact and we'll do anything.
Very important.
Mr. So-and-so is present for the private respondents. Number, it was. Yes,
Highly pleasure.
Item number 8.
give me item number 32 also. Hey, Ranu, same order about the Belek same order. This court, first of all, the present interlocutory application has been instituted by the applicants, who are the respondents number 5 and 7 in the connected writ petition being WPC number 254/2024, praying for permitting them to file their respective affidavit, which prayer was rejected by this court-wide order dated 5/5/2026, passed in WPC number 25/2024 on the ground of the delay occasioning in filing of such affidavit by the said respondents. Oh, no. Wide order dated 26/3/2026 and 27/4/2026. 5/3/55 now, Full stop. I have considered the submissions made by the petitioner, by the applicants in the present interlocutory application, and also heard the learned counsel for the applicants. The learned counsel for the opposite party number 1 / writ petitioner has submitted that the respondents had delayed filing of the affidavits, their respective affidavits, only with the view to delay conclusion of the present proceedings. However, he submits that for the ends of justice, in the event the court permits the respondents number 5 and 7 to bring on record their affidavit, he would have no objection, subject to the fact that he be granted further 2 weeks' time to file a rejoinder thereto. First of all, I have considered the submissions made by the learned counsel for the parties. Also, this court, having expressly rejected the prayers made by the petitioners, by the respondent number 5 and 7 to file their affidavits, while the orders dated 26/3/2026 26/3/2026 and 27/4/2026, this court is of the considered view that the acceptance of the prayer made by the petitioners in the present writ petition would be so permissible only with the imposition of a cost. Accordingly, the prayer made in the present application, interlocutory application, is accepted subject to the payment of a cost of ₹5,000 each by the respondent number 5. Okay, 2,500 each by the respondent number 5 and 7 respectively. The said amount be deposited with the registry of this court within a week from today. On the deposit of such amount being made, the registry would permit the respondents number 5 and 7 to file their respective affidavits. So the amount being so deposited, the registry shall transfer the same to the account of the Gauhati High Court Bar Association Kohima for utilization of the same in its activities. With the above observation and direction, the present interlocutory application stands disposed of. Next item number 32. 100. It would khali respondent number 6. So khali here would be 2,500. Take that. Same. Baki. A connected writ petition or there. Registry to list this matter. So in view of the orders passed today in I number 86/2026 and I bracketed C number 100 of 20, I bracketed C 86, 100 of 2026, permitting the respondents number 5, 6, and 7 to file their respective affidavits by way upon deposit of the cost so imposed, comma. It is provided that the registry after deposit of such amount or cost except the permit the respondents to bring on record their respective affidavits. On such filing of the affidavits, the petitioner is granted further. In view of the above, the petitioner is granted further 3 weeks time to file a rejoinder thereto. Registry to list this matter after 3 weeks on a date to be fixed by it. Now, if you want to do something more for your bar, I can increase that cost amount.
Fair Haven, item number 9.
You are assailing the penalty imposed upon you.
And assailing the penalty as well as the conviction.
Both.
Yes.
Then why is not an appeal filed? A revision has been filed.
Yes.
I'm not sure. Just address why. Because you have nothing to do. You have not alleged anything with regard to the manner in which the proceedings were held.
Yes.
You are with regard to the merit of the conviction and the. So will a revision be maintainable, or it should be appeal? Appeal, huh?
Yes. Now, my lord,
How old are you now?
I'll be 42 this year.
No, not you. The petitioner.
Okay.
The petitioner. The petitioner.
My lord, he is, I believe, nearing 70 or around 70 years. And
He'll be much above 70. He'll be
Yes.
73 or something.
Yes.
Was he under detention at any point of time after the
Yes.
registration of the case? How many days?
For a few days only, my lord.
Few days.
Yes, my lord. And he has been.
What is he? What is he? He is basically his role is as a middleman here.
Yes, the allegation, as per the allegation.
Allegation, he is a middle
He was a
convict. He was a convict between those two
Yes,
contractors and this.
as per the allegation. He was a registered government contractor.
He was. And the allegations that are there, the materials that have come on record,
Yes.
your conviction will not mandate an interference. You can argue subject to.
Yes,
You
Lord.
can argue on the other point of your whether there is a need. When was the case registered? FIR registered?
In 2007.
7.
Yes,
So after around 14, 15 years, whether it's a fit case for you, for this court to insist upon your imprisonment, undergo the imprisonment,
My lord.
or we can grant you probation. So that's basically the area which would be required to be examined.
Otherwise, my lord, I have.
Conviction.
For this honorable court, my lord, under the impression that I have a very good case.
You have a good case, but the prima facie view of this court on perusal of the materials is that it was established.
Lordship.
Yes, what do you say?
Lordship, the computer that was seized from his residence from which the receipts were printed.
Printed out,
And the,
which was sent to the,
it is different.
yes. How is a revision maintainable, Mr.?
My lord, since your lordship at the rightly pointed out to the file appeal.
You examine this issue. You examine this issue. We'll take it up some other day. If you find that a revision is not to be, it should be registered as a appeal, file a interlocutory application with on the prayer of the learned counsel for the petitioner. You're still on bail. You're on bail.
Yes, my sentence has been
Suspended because the trial court had also granted you bail.
The petitioner is also criminally ill.
You get those things on record. On the prayer of the learned counsel for the petitioner, registry to list this matter again on 9/9/6 or 2/6. 2/6? 9/6. 9/6/2026. In the meantime, if that is there, you take steps.
My lord.
Okay.
Take your place.
Item number 10.
Hey, just a thing. There is one more petition along with this. Just see. That one, the first one. It is 296 or something. No? What is it? No, 176 is yours. There is another writ petition. Okay. Okay. That is 296. There is one more writ petition. Just check up. Only this. And 296. It's okay. It's so the respondent number 4 herein had filed the 296 against cancellation of her that indigenous certificate. Now, after cancellation of that, you had filed this thing. This went up to the division bench. This writ petition was restored. Along with your case, it was directed to be heard. Now you have withdrawn this. So your cancellation stands.
Yes.
Your cancellation stands. So then that means you have got no grievance with regard to your termination of your services.
Number 4 hearing, she was married to another district. So with an instruction to withdraw 296.
You have withdrawn 296. So the grievance with regard to your indigenous certificate cancellation goes. Right?
Yes.
So now here the prayer number 1, 2 stands allowed because here it is with regard to cancellation of the indigenous certificate, which has already been cancelled by the state. So that prayer is gone. Prayer number 2 is your cancellation of your selection. That is also gone.
That is
Now, what about the prayer number 3?
that is because
What is your merit position in the selection process?
my very possession is 700.
Where do I get it?
If we come the page number. Page number 26. The name of the product is oral number, he figured 701. Now our selection.
Now, what has happened to this post, Mr. Imsang? What has happened to this post?
Still again.
Is there any order passed by this court that
What is missing a big edition, which is the administrative forms. It's order dated. When order dated. 4/3/2022. Kasi para
Para.
Para Viva. The additional to be commercial proposal, Nagaland is strategic to allow Serimba students, that is a private respondent. The respondent report to train their service as paper facing. There was a direction passed by the administrative judge. This direction was passed was suspended by the division bench in written. So in terms of the direction passed by the division bench, the post is still there.
So that judgment was interfered with by the division bench.
But
Then it came back.
secure the cases. Immediately now, since our indigenous independence card, it is an embedded fact that the private respondent,
What is the date of that select list? 19.
2019.
And when was the first proceeding instituted by you? 2019. So, yes, Mr. Info, what to do? The matter is pending before this court, so the select list has to be deemed to have been extended. Now the respondent number 4, she is gone. So there is nothing left here. Consider his case.
The very fact is, the private respondent, she appeared in the agreement with a fact.
That is gone now.
So it is a settled principle that when somebody obtains an appointment on the basis of fact appointment, the next report is that has to be cancelled in the eligible candidate has to approve.
So now let's come to that. That's the settled position. Now her candidature after the orders passed was cancelled. Her indigenous certificate was verified and that was cancelled, leading to consequential cancellation of her selection. She was appointed. She was not appointed.
She was appointed.
She joined.
No, she's not joined.
Joined. Suspended because of this aspect. Now she has presented a challenge to her cancellation of her selection as well as the indigenous certificate. 296. So 296 was pending when your 176 was disposed of by this court. You went up on appeal. And therein the appellate court said, no, that issue in 296 is to be decided along with 176 when after 176 is restored to the file. Accordingly, the court directed for restoration of 176. Both matters come back. Then the prayer is made by the learned counsel for the petitioner in 296 for withdrawal. So it goes. Along with it goes the challenge to her cancellation as well as cancellation of her selection as well as the indigenous certificate.
In 196, it was putting the cancellation of her indigenous.
No, 296. 296.
So when she withdrew this recognition,
that is gone.
She's accepting about her cancellation.
So the deputy commissioner's order there gets revived. It survives. So now today, she does not have the qualification to participate in the selection process. So if she is not there, you are there. You being the second candidate and the proceedings being pending here since after the publication of the select list, the select list is deemed to have been extended. Okay. So we allow it. Madam, we allow it. Just take down their names. Write it. Heard the learned counsel for the parties at some length. Hearing remains inconclusive. Tomorrow, how many matters are there in the division bench? Can you just check up?
The respondent will directed to appoint me within time frame.
Yes, sure. Yes, we'll do that. How many would be there? 10, 15, 20? 20. Can I come back and dictate this order tomorrow? I raised it to list this matter again tomorrow. After the division bench, we'll pass the orders.
Item number
Take down
11.
their names. Just take down their names. He is Lima. No? The council was arguing he is Lima. Lima Wapang, Mr. Wapang. Can you just write down the names? Ask your junior to write down the names of all the councils appearing so that I can just put it. Yes. Yes, Mr. Lankumer.
Yes. About this matter,
Compassionate appointment.
professional appointment. Now, the petition is.
When did your predecessor in interest die in harness?
2022 Lordship.
And you are at serial number 33.
That was the, as per the first list that was served to me.
So if you are challenging the others, have you made them party respondents?
No, Lordship, I have not. I'm just indicating, Lordship. that,
Then.
Modus operandi of.
Then. Yes, madam, what do you say?
Lordship, I make it now, Lordship, to place the letters wording this. Right. Lordship, as per the base, Lordship, the petition stands in serial number 45. 45. This is the latest condition.
How from 33 to 45? Now tell me, a person whose father or somebody who had expired in 2008, where is the need for compassionate appointment in 2025? Mr. Lankuman,
Yes, Lordship.
you want a relief?
Yes, Lordship.
Do some service for the state, for the others. Amend your writ petition, make a challenge to that policy. Read two decisions of the Gauhati High Court. One is, ki asile tu? Achyut Ranjan Das, my Lord Justice Gogoi's order, and Fazirun Nessa, my Lord Justice B.K. Sharma's order. You type this too, you will get it. And State of West Bengal versus Debobroto Tiwari. Asana citation to D division. She'll give you that citation. Read it. Now, see, the problem here in the scheme is what I find, because I can't touch it because there is no challenge to that. So the challenge, the problem with the scheme is, it says that Group C, Group D 50%.
Yes.
It goes further to say that a list would be prepared basing on the date of death.
Yes.
Now, what is happening, what I find is, people are coming up, making up applications as per their own convenience.
Yes, sir.
So now Madam has said you were in 33, now you have gone in 45. In the meantime, many people may have come up and filed an application for compassionate appointment. Now you find that persons of 2008 are still in the line for a compassionate appointment. Mind you, this is not heritable. It's immediate. Compassionate appointment means immediate.
Yes.
There are only two criteria that are required to be applied. One is immediate man has gone, immediate succor, you appoint him. Two, the financial capacity of that family to tide over that position. If it does not have, you will have to provide. If it has, you did not provide. For that, there has to be an assessment of the financial condition, everything. Pension, if there are earning members, then if there are 7 members, if it is 5 lakhs, it would work out per head to so and so. If there are 10, it would work out. So the person having family having 10 would be in more need.
Yes.
So it is how that scheme has to be formulated. Unfortunately, here the application is at the wish of the person making, because he makes it after 20 years also, he'll get back that position in terms of death. That cannot be. That you will get it in Debobroto Tiwari. Supreme Court has said, immediate lapse of time, the application becomes stale.
Yes.
So if you can amend this to that extent, make a challenge, read those two judgments, ask us to come in and formulate the guidelines accordingly, requiring the state to amend its thing, I think it'll solve the issue.
Yes, and there is a subsequent addendum there.
And madam, see, there is a big thing, a big disservice being done. What is that? I'll tell you. Say a person whose father died in 2010. He is waiting in expectation that he will get a job. Last 15 years of his life he has spent in that expectation. You have destroyed his life. Do you get my point? What has happened because you are making that person expecting that legitimate expectation or not, that we can take care. But that person's expectation is there that the government will give me a job. He is waiting. He's not doing anything. He is just whiling away his productive years. That is crime. That, according to me, is crime. You should not.
Lordship, even in my petition, my effort was to just point out to the court that the way the modus operandi.
No, modus operandi, say these are the things you will have, these are the loopholes there.
Yes.
You will have to plug that. Then only you can, because I can't catch the government now. Because I know, madam, tomorrow I ask her why it is 33 to 45. Her answer would be no, those applications had come in where the persons earlier. So they are left with no other alternative. They have to place it there. So get it done. On the prayer of the learned counsel for the petitioner, registry to list this matter after 2 weeks on a date to be fixed by it. You read those three judgments, find out, see the other Supreme Court judgments also, mold it, and then that judgment in Achut had revolutionized the concept of compassionate appointment in Assam. There were 2 committees set up. One is a district level committee and another is a state level committee. The committee now is to look into the financial capacity of the family. Then it recommends to the state level committee. Thereafter only the appointments can be made by the department. Look into it. If we can do something similar here.
Yes.
Okay. And in Debobrata Tiwari, all you will get delays, everything is there. But one line there is that compassionate appointment, you can't claim it as a matter of inheritance. But you have now converted it to a matter of inheritance. If you say somebody has a right for compassionate appointment, it is immediate, madam. Let it get, you get it. Let the government also take requisite action. Then we'll see what can be done. Yes.
Other questions?
Item number 33.
30? Ah. Yes.
What's here? The petitioner, he was serving as a clerk cum cashier in the
Nagaland Rural Bank.
US one. Now, he was transferred from
You are paying for the bank.
one branch, that is Chipopozoa, which is under Kohima district, to Woka. Now, after his transfer, the reliever of the present petitioner, he complained to the bank that there is a discrepancy of about 51,000 in the money that the petitioner has handled while he was serving as the clerk of guest. Now, again, the chairman and chief inspector Nagaland Rural Bank
Can you put on this man?
informed that there was a discrepancy of 3,57,000. And a direction was given to the petitioner that the shortfall amount must be replenished, must be credited by him to the bank. Therefore, the petitioner complied. Now, the after the replenishment, my lord, the petitioner was put under suspension by the order dated 17th of August 2017 by the Chairman of the Disciplinary Authority, Nagaland Rural Government. And by order dated 15/11/2017, disciplinary proceedings and charging was given to the petitioner, was furnished to the petitioner, was served. Then, thereafter, disciplinary proceedings were held against the petitioner on 3 different dates. That is 15th of June 2018, 3rd of July 2018, and 7th of August 2018, respectively. Now, thereafter, Lordship, by order dated 7/2/2019, the petitioner was terminated from service on the ground that his reply to the charge sheet and to the charges
Where is that order?
was not satisfactory.
Where is that order?
Annexure 10, my lord. Annexure 11, page 71, Lordship.
No, this is the inquiry thing.
Yes, Lordship.
You were asked to appear in the inquiry.
Yes, Lordship.
Your penalty order is subsequent.
Yes, Lordship. Now,
Penalty order is at page 90.
yes.
Now tell me.
His reply, my lord.
No. Your penalty order is page 90.
Yes, Lordship. But on the ground that the written statement of defense is not convincing.
Where do I get it?
Page 71.
71 is inquiry,
Yes,
naturally.
Yes.
Because your inquiry, your statement is not proper.
Yes.
That is why they said inquiry.
Yes.
What is the harm there? You will be given a fair and reasonable opportunity, so and so. This is for the inquiry.
Yes, Lordship.
You participated in the inquiry. You
Yes,
admitted to all the charges except one transaction, Ashraf Ansari. Right? And then the penalty comes with regard to your imposed or termination from service, removal.
Yes, Lordship.
Now tell me what is the error here? You admitted your allegations in your reply.
Lordship.
You admitted that in the inquiry, barring Ashraf Ansari, that one transaction,
Yes, Lordship.
4,000 rupees or something. Rest you said that, yes, I did it, but I replenished it.
Yes, Lordship.
Your replenishment is of no consequence.
Lordship.
It's of no consequence because your replenishment only shows your guilt.
Yes.
Now you are a bank employee. The question of loss of confidence comes.
Yes.
Why should we interfere with that penalty?
If that is the opinion of the court, then
Never go by the opinions of court because courts have no opinion. This is just disclosure of my thought process to you.
it's never.
You counter. You come down heavily on me. I'm waiting for that.
Lordship, in that case,
Hmm.
Lordship, in that case, if we can continue at 2 or on Thursday, Lordship. I was, Lordship, expecting the hearing item number 9 to be taken up today, which is why I had thoroughly prepared that hearing item number 9. And because of paucity of time, my lord, I could not even get my books in order in this manner,
Okay. Well, give him. Let him prepare.
my lord. After tomorrow.
Remember, Mr. Counsel,
Yes, I have a task not to crack, my lord.
Uh,
And
You being a bank employee, you are placed like a member in a discipline force.
My lord, my lord,
And the concept is loss of confidence.
my lord.
Any small minor aberrations in the inquiry
Lord,
would be not coming in your favor.
my lord.
It will be in favor of the bank.
Yes,
So you got to traverse accordingly.
my lord.
On the prayer of the Learned Counsel for the petition, not objected to by the Learned Counsel for the respondents, registry to list this matter again on Thursday,
21st. Just Thursday is
21st, 21.
Good job, that's right.
No, please finished. Give me those, give me those. Madam, you have finished that yesterday's one.
Now, judgment,
Can you take-
item number 15 to 17.
No, you want, I can dictate there also. Here only, fine. Let us take up item number. Do it like this. Just suffice. I'll come back by 12. Madam, you finish up those. By 12, I'll dictate this to you. 12 o'clock. I'll come back at 12 and dictate. There's 3 matters, but only the facts would be different. The further conclusions and everything would be the same. So if you type out one, the other 2 would be made. There's no problem. I'll come back at 12. If you're not here also, no problem. Really. WPC 304/2024. That is item number 16. First. Heard Mr. T.B. Jamil, Learned Counsel for the petitioner. Also heard Mr. B. Deka, Learned CGC. Who is Ms. K. Tushukru appearing for?
She's the government.
Okay, along with Ms. T. Tushukru, Learned B. Deka, CGC, along with Ms. T. K. Tushukru appearing for the respondents. The petitioner, by way of petitioner in the present proceedings, has prayed for the following reliefs. A to A at page 12. You write like this, has prayed for a direction upon the respondent authorities to regularize his services against the post of marketing specialist in the Central Institute of Horticulture, Medzifema. Right. Next para. The director, Central Institute of Horticulture, Medzifema, that is the respondent number 4 herein, had issued an advertisement for recruitment, amongst others, against a post of marketing specialist, on contractual basis for a period of 6 months or till regular appointment is made against the said post. The post of marketing specialist as advertised was a sanctioned vacant post. First of all, the petitioner, having fulfilled the requisite eligibility criteria as set out in the said advertisement dated 13/2/2009, had submitted his application and thereafter participated in a selection process conducted for the purpose of engagement against the post of marketing specialist as advertised. Full stop. In pursuance to the said selection process, the selection committee as constituted in the matter had found the petitioner, had selected the petitioner for engagement against the post of marketing specialist, and the said recommendation was placed before the competent authority of the Central Institute of Horticulture. First of all, the recommendations of the selection committee were thereafter forwarded by the respondent number 4 to the Horticulture Commissioner, Department of Agriculture and Roman and Corporation, Ministry of Agriculture, Government of India for approval. First of all, on approval being so granted by the competent authority, the respondent number 4 issued an offer of appointment dated 27/11/2009 to the petitioner hearing for his engagement against the post of marketing specialist on contractual basis. The petitioner accepted the said engagement and joined his services. So the petitioner on joining his such engagement was paid his remuneration on a fixed pay basis. Full stop. Although the initial engagement of the petitioner was for a period of 6 months, the same was being extended from time to time. First of all, along with a revision of the wages earned by the petitioner against the said post, For subpara. The post of marketing specialist being a sanctioned post, comma, a process of recruitment was initiated against the said post wide issuance of an advertisement bearing number 02/2023 dated 28/1/2023 by the Union Public Service Commission (UPSC). The petitioner, along with 124 others, had submitted their respective applications against the said post. On a scrutiny of the applications so received, comma, it was found that only the petitioner and one another came to be shortlisted for the interview for selection against the said post. However, via a communication dated 15/7/2024, the UPSC authorities decided not to proceed with the selection process as initiated in the matter any further, and it was held that the recruitment against the post of marketing specialist / economist as advertised by the said advertisement dated 28/1/2023 had become infructuous. The petitioner accordingly continued against the said post, however, on contractual basis. It is to be noted that the petitioner, along with other similarly situated employees, engaged on contractual basis against various other posts in the Central Institute of Horticulture, Medzi Pema, had submitted applications before the respondent authorities praying for regularization of their services against the posts held by them. However, the said prayer not being considered favorably, the petitioner has approached this court with praying for the reliefs as noticed herein above. Full stop. At this stage, this court would notice that similarly situated persons engaged on contractual basis like the petitioner had approached this court earlier by way of instituting writ petitions being WPC number 38/2023 Sri Arvind Singh versus Union of India and others, and WPC number 39/2023 Sri Anjani Kumar Singh versus Union of India and others. A coordinate bench of this court wide judgment and order dated 27/11/2024 on considering the issues arising in the said writ petitions was pleased to dispose of the said writ petitions by directing the respondent authorities to regularize the services of the petitioners involved in the above noted two writ petitions. Full stop. The respondents herein being aggrieved by the said judgment and order dated 27/11/2024 passed by the coordinate bench of this court in WPC number 35/2023 and WPC number 39/2023 had assailed the same by way of instituting writ appeals being WA writ appeal number 12/2025 and writ appeal number 13/2025. A division bench of this court wide judgment dated 7/3/2026 on a consideration of the issues arising in the said writ petition proceeded to allow the said writ petitions affirming the judgment and order passed by the coordinate bench of this court wide judgment and order dated 27/11/2024 passed by the coordinate bench of this court in WPC number 38/2023 and WPC number 39/2023. However, with certain modifications therein. Also, the learned counsel for the petition, by referring to the decisions of the coordinate bench of this court as well as of the division bench, has submitted that the said decisions squarely applies to the case of the petitioner in the present proceedings, and accordingly his direction would be mandated to be issued upon the respondent authorities to also regularize the services of the petitioner herein. Mr. B. Deka, next, Mr. B. Deka, learned CGC, appearing for the respondents, has fairly not disputed the contentions raised by the petitioner, by the learned counsel for the petitioner in the matter, and has submitted that the petitioners are also similarly placed like the petitioners in WPC number so and so and so and so, 38, so and so and so and so. I have considered, full stop, I have heard the learned counsel for the parties and considered the materials coming on record. The petitioner herein was admittedly recruited against a sanctioned vacant post of marketing specialist, and with effect from the date of his initial engagement, that is with effect from 27/11/2009, the petitioner is found to have been constantly discharging his duties against the said post, albeit on contractual basis. The petitioners in WPC number 38/2023 and WPC number 39/2023 is also found to have been recruited against sanctioned vacant post in the Central Institute of Horticulture, Medjipa. No, subsequently were also found to be engaged against sanction. They were against first, I'm not bringing that in, against a post on a technical consultant, then subsequent interview, they were brought here. Also, against sanctioned vacant posts. Also, a coordinate bench of this court, wide judgment and order dated 7/3/2026, had disposed of the said writ petitions by directing the respondent authorities to regularize the services of the said two writ petitioners from the date of their initial appointments. Full stop. The said judgment was assailed by the respondent authorities herein before the division bench of this court by way of instituting writ appeal number 12/2025 and writ appeal number 13/2025. A division bench of this court, upon considering the issues arising in the said writ appeals, was pleased wide judgment and order dated 7/3/2026 to dispose of the said writ appeals by directing as follows. Page 23, conclusion, A to A. Also, a perusal of the said decisions, a perusal of the said conclusions drawn by the division bench of this court, wide the said judgment and order dated 7/3/2026 would reveal that the direction for regularization of the services of the petitioners in WPC number 38/2023 and WPC number 39/2023 against the post held by them in the Central Institute of Horticulture, Medzipama, was as directed by the coordinate bench of this court was upheld. However, it was provided that the regularization of the services of the petitioners therein would be from the date of the judgment passed by the division bench that is with effect from 7/3/2026. Also, having considered the service status of the petitioner here in the present proceedings in the light of the decisions of the coordinate bench of this court in WPC number 38/2023 and WPC number 39/2023, as well as the decision of the division bench in WA number 12/2025 and WA 13/2025, this court is of the considered view that the said decisions would squarely apply to the case of the petitioners herein, and the same has also not been disputed by the learned counsel for the respondents. Accordingly, accordingly, the respondent authorities are directed to regularize the services of the petitioner herein against the post of marketing specialist with effect from today. Right? With effect from today, that is so and so. Today's date. First of all, with effect from today, the orders towards regularization of the services of the petitioner be issued within a period of 3 months from the date of receipt of a certified copy of this order. Full stop. However, they'll put it like this. Cut that. Accordingly, it is directed that the respondent authorities shall pass appropriate orders towards a regularization of the services of the petitioner herein against the post of horticulture specialist, marketing specialist, within a period of 3 months from the date of receipt of a certified copy of this order. It is provided that the effect of regularization in respect of the petitioner herein against the post of marketing specialist be so given with effect from today, that is today's 19/6/2026. With the above observations and directions, the present writ petition stands disposed of. Right? Now you take up WPC 305/2024. Same. You are the counsel assisting B. Deca. We have put your name also. The respondent number, that regularization, that you're right. The petitioner, by way of instituting the present writ petition, has prayed for the following reliefs. Page 14A to A. Right? A to A. The respondent number 4, wide advertisement dated, issued above. Respondent number 4 issued an advertisement dated 20/10/2018, inviting applications from eligible candidates for filling up of 2 posts of consultant (technical) on contract basis for a period not exceeding 12 months for undertaking various activities in the Central Institute of Horticulture, Medzi, Pema. The petitioner, having satisfied the eligibility criteria as set out in the advertisement, submitted her application for being considered for engagement as consultant technical in the Central Institute of Horticulture, Medzi, Pema. Also, the petitioner thereafter was permitted to appear in a selection process, and on conclusion of the said selection process, the selection committee as constituted recommended the name of the petitioner for being engaged as consultant (technical) in the Central Institute of Horticulture, Medzi, Pema, as against the post, again in terms of the advertisement dated 20/10/2018. First of all, the said recommendation of the selection committee having received the approval of the competent authorities, the petitioner was on order dated 9/1/2009 engaged as a consultant (technical) in the Central Institute of Horticulture, Medzi, Pema, Nagaland. Also, subpara. As the petitioner was continuing against her engagement as consultant (technical) in the said institute, a further advertisement dated 13/2/2009, inviting applications, amongst others, for 3 posts of assistant horticulture specialist. So it is to be noted that the posts of horticulture specialist as advertised were sanctioned posts. So the petitioner being eligible for being the petitioner having satisfied the requisite eligibility criteria as set out for recruitment against the post of assistant horticulture specialist, proceeded to submit her application in pursuance to the said advertisement. The petitioner thereafter participated in a selection committee, and on conclusion of the said selection committee, the petitioner, along with 2 others, were recommended for engagement against the posts of assistant horticulture specialist as advertised. So, the recommendation of the selection committee having been approved by all the approved by the authorities concerned, the respondent number 4 issued an offer of appointment dated 27/11/2019 towards engaging the petitioner against the post of assistant horticulture specialist. The petitioner joined her services against the said post and has been continuing against the same and was joined the post against so and so. It is to be noted that the advertisement as well as the engagement of the petitioner against the post of assistant horticulture specialist was on contractual basis, and the same was initially for a period of 6 months. However, such engagement of the petitioner was continued from time to time and is also was continued from time to time. The petitioner, while serving as an assistant horticulture specialist, she was via an order circular dated 14/1/2011 permitted to hold the post of horticulture specialist, assistant horticulture specialist, was hold the post of horticulture specialist in the Central Institute of Horticulture, Medzipama. Thereafter, via an order dated 1/6/2011, the petitioner was appointed to the post of horticulture specialist on contract basis for a period of 6 months. However, the said engagement was continued with till the date of institution of the present writ petition. Also, the petitioner in the present writ petition has accordingly prayed that on being recruited to the post of she being regularized against the post of assistant horticulture specialist in the institute, be directed to be appointed against the post of horticulture specialist by she be recruited against the post of horticulture specialist by way of promotion. So, I've heard the learned account at this stage that case earlier thing at this stage, notice everything would be the same. Only the post marketing specialist will be now assistant horticulture specialist. After you have noted those things, right, heard the learned counsel for the petitioner, and Mr. B. Decca, I have read now, said there that he has agreed. However, Mr. B. Decca, learned counsel for the learned CGC, has submitted that the petitioner's initial recruitment against the post of assistant horticulture specialist being in pursuance to a process of recruitment initiated in the matter, her regularization would only be mandated to be directed against the post of assistant horticulture specialist. He submits that the post of horticulture specialist is a promotional post from the post of assistant horticulture specialist, and no direction would be mandated to be issued for promoting the petitioner to the said post, inasmuch as such promotion would mandate the fulfillment of the requisite eligibility criteria which have been set out.
Yeah, 60% by direct.
Also, Mr. B. Decca submits that the recruitment to the post of horticulture specialist in terms of the provisions of what is that rule called? In terms of the provisions of the rules holding the field is to be so effective by way of direct recruitment to the extent of (22) by way of direct recruitment as well as by way of promotion to the extent of 50% each of the cadre strength of the post of horticulture specialist. It is submitted that the petitioner, in the event of being regularized, a petitioner being now required to be regularized in her services with prospective effect, does not possess the requisite eligibility criteria for her immediate promotion to the post of horticulture specialist. Accordingly, he submits that the prayer of the petitioner for also a prayer of a petitioner for a direction for her promotion to the post of horticulture specialist would not mandate an acceptance from this court. Then you copy paste the rest. Till the directions, just above the directions. Directions you write. This court has considered the decisions of the coordinate bench of this court passed in WPC number 38/2023 and WPC number 39/2023 and finds, along with the decision of the division bench of this court in WA number so and so and so and so, and finds that the said decisions squarely apply to the case of the petitioner herein. The petitioner having been recruited to the post of assistant horticulture specialist, by way of process of recruitment, in view of the said decisions of this court, the petitioner's services as a horticulture against the post of assistant horticulture specialist in the Central Institute of Horticulture, Medjis, Pema, would be required to be so directed. Accordingly, it is directed that the respondent authorities shall, within a period of 3 months from today, shall proceed to issue orders regularizing the services of the petitioner against the post of assistant horticulture specialist within a period of 3 months from the date of receipt of a certified copy of this order. It is provided that the regularization as directed to be effected in respect of the in case of the petitioner herein shall be so effected with effect from today, that is 19/6/2026, 19/5/2026. 6, that she will correct. 19/5. That was there. Also, the prayer of the petitioner for a further direction to promote her to the post of horticulture specialist has been considered by this court, and this court finds that the petitioner having been directed to be regularized in her services as assistant horticulture specialist with effect from today, that is 19/5/2026, the petitioner is found to have not gathered the requisite eligibility criteria for promotion and or direct recruitment. No, promotion for promotion. But your regularization is from today. Is found to have not fulfilled the not achieved the requisite eligibility criteria for promotion to the post of horticulture specialist. Also, the rules holding the field mandate that for promotion to the post of horticulture specialist, incumbent in the cadre of in the post of assistant horticulture specialist must have completed 5 years of regular service and also should have successfully completed 2 to 4 weeks training program in field of horticulture from a recognized institute. The petitioner, having been directed by this court by the present order to be regularized in her services with effect from today, that is 19/5/2026, the petitioner cannot be held to have completed 5 years of assistant horticulture specialist. Accordingly, the said prayer of the petitioner stands rejected. With the above observations and directions, the present petition stands disposed of. Next, 310/2024. Please. Feel free to submit.
Worship in the prayer, Worship, yesterday the CGC has pointed out that A and B. B is not a sanction post, Worship.
That this third case,
Case here.
Intinaro.
If your Worship credited the prayer portion page 14.
Okay.
In A is like PA to director, and the B is admin and account experts. Also, I said that this is a sanction post.
This is a sanction post. There is no problem with that. But your statement in paragraph 15, page 10. Second para to provide, we can call it a proviso. No, it is pertinent to mention here that though the petitioner has been appointed as admin accounts expert, she is still discharging the duties of PA to director CIH Medzipema.
That is just an additional.
And there is no recruitment against this post.
Is there a Worship pursuant to an advertisement?
Okay, if it is 31/5/2024, how can we now regularize her within 2 years against that post? She will not be entitled. 2 years only service. She's only rendered 2 years service against that post. 24. And you are saying as of 2024, when you filed this writ petition, you have still not discharging duties against that post. So your post would be PA.
Regularize her in the post of PA as well as in the.
No. It would be only PA. Because see, here PA is from 2009 along with the others.
9.
And she has been continuing against that post. She appeared in an interview, no problem. Contractual thing. But your own statement here is that you were continuing as the admin. You have continuing as the PA to director.
That's an additional charge here.
Additional charge will not, because 2 years, again, that Uma Devi would come in. 10 years. So your entitlement would be, or you wait for some time, withdraw this, wait for some time, come back again. You get your PA to director, that much we can provide for, nothing else. The petitioner, by way of petitioner in the present petition, next one, has prayed for the following reliefs. A, page 14, A2, A. A and B, there are A and B, just quote that. The respondent number 4 while an advertisement dated 13/2/2009 invited applications amongst others for the post of personal assistant to the director of the institute, personal assistant, put in bracket PA, to the director of the institute for invited applications for engagement on contractual basis for a period of 6 months against the post of personal assistant bracket PA to the director. The petitioner, having satisfied the eligible petitioner, having found that she had satisfied the eligibility criteria as set out for the said post in the advertisement dated 13/2/2009, had submitted her application for recruitment against the said post. So thereafter, the petitioner had participated in a selection process, and on conclusion of the selection process, the constituted selection committee had recommended the name of the petitioner for engagement against the post of PA to the director of the institute. So the recommendations of the selection committee having been approved by the competent authorities, the petitioner was offered an appointment while order dated 27/11/2009 against the post of PA to the director on contract basis initially for a period of 6 months. So they said engagement and joined her services. Although the initial engagement of the petitioner was for a period of 6 months, they said the services of the petitioner was continued against the said post. So it is to be noticed that subsequently, the respondent number 4 had issued a further advertisement dated 23/1/2024, inviting applications from eligible persons for engagement against a post of admin and account resource person. What is it? Admin and account expert. The petitioner, having fulfilled the eligibility criteria set out in the said advertisement, submitted her application for recruitment against the post of admin cum accounts expert. Full stop. Thereafter, the petitioner participated in a selection process. Full stop. On conclusion of the selection process, the selection committee recommended the name of the petitioner for engagement against the post of admin and accounts expert, and accordingly, offer of appointment dated 28/2024 was issued to the petitioner by the respondent number 4. Also, the petitioner in the writ petition has contended that although she was appointed as admin and accounts against the post of admin and accounts expert, she was continuing to discharge her duties as the personal assistant to the director of the institute. The petitioner in the present writ petition has prayed for a direction to regularize her services against the post of PA to director in the institute, and thereafter to regularize her services against the post of admin and accounts expert in CIH. Also, then the same thing will go on. Now, Mr. B. Deka, submission of Mr. B. Deka. Mr. B. Deka has submitted that with regard to the prayer of the petitioner for regularization of her services against the post of PA to director of the institute, the same would be covered by the decisions of the coordinate bench of this court as well as of the division bench as noticed herein above. He submits that he would have no objection to the such directions being passed by this court in favor of the petitioner hearing. However, with regard to the prayer of the petitioner for regularization of her services against the post of admin and accounts expert in the institute in pursuance to her engagement against the same, while the order dated 28/2024, it is submitted that the petitioner would not be entitled to the said direction inasmuch as the services rendered by the petitioner against the said post was only for around few months before institution of the present writ petition. He further submits that the petitioner in the writ petition has also categorically contended that even after the engagement, even after her engagement against the post of admin and accounts expert, she had continued to discharge her duties as the PA to the director CIH Medzipema. CIH means Central Institute of Horticulture, Medzipema. So accordingly, he submits that the prayer of the petitioner for also regularization of her services against the post of admin and accounts expert would not mandate a consideration from this court. Then the court's judgment and all you quote come to the last paragraph. In view of the above discussion, this court is of the considered view that the claim of the petitioner for regularization of her services against the post of PA to the director of Central Institute of Horticulture, Medzipema is squarely covered by the decisions of the coordinate bench of this court in WPC number so and so and so and so, as well as the decision of the division bench of this court in WA number 12/12 and 13, 2023. Accordingly, the respondent authorities are directed to regularize the services of are directed to issue orders towards regularization of the services of the petitioner against the post of PA to the director of the institute within a period of 3 months from the date of receipt of a certified copy of this order. It is further provided that the regularization of the services of the petitioner be made so effective with effect from today, that is 19/5/2026. Having drawn the above conclusions, this court would now consider the prayer of the petitioner for a further direction to also regularize her services against the post of admin and accounts expert in pursuance to her engagement therein, while the offer of appointment dated 28/2024. The said prayer was objected to by the learned CGC appearing for the respondents. This court finds that the petitioner was engaged against the post of admin and accounts expert only with effect from 28/2024. The petitioner has in the writ petition, more particularly in para 15 of the writ petition, made the following contention. Page 10, B to B. A perusal of the said contention would reveal that the petitioner, although was engaged as admin and accounts expert, had not served against the said post and continued to serve against the post of PA to director at the time of institution of the present writ petition. Further, the petitioner, even if thereafter had served against the post of admin and accounts expert, such service rendered by the petitioner is found to be only for a very short period of time before institution of proceedings and or during pendency of the present writ petition. Accordingly, the prayer of the petitioner for issuance of a direction upon the respondent authorities to also regularize her services against the post of admin and accounts expert does not find favor from this court, would not mandate an acceptance from this court, and accordingly, the said prayer stands rejected. The petitioner would be now only entitled to have her services regularized against the post of PA to the director, CIH. CIH means Central Institute. Medzipama. With the above observations and directions, the present writ petition stands disposed of. Yes.
The nomenclature of PA to director has been changed to stenographer grade.
Okay.
If I may continue. And now the nomenclature of the stenographer grade 1 has been changed to assistant in bracket admin and accounts.
You have written not there earlier against the post of PA and or the post currently being held by the petitioner. PA or PA oblique, you just write down in a piece of paper and give it to me, I'll incorporate it.
And the nomenclature they have also stated in their affidavit, page number 7, as stenographer 1, PA to stenographer 1. The change of nomenclature was proposed by the CIS in the Suprema, and by that order, the ministry has.
Do you have the qualification against this post? Stenography post you have? Stenography?
I was in one of my appointment, there's reflected as stenographer.
Okay. I'll do the info. You give it to me, I'll do the info. Put this inside this. I'll do the info. All three disposed of. Get the orders by Friday. The right words.
If I'm not Mr. Rogan, I'm clear about the event of that. Yeah. I go to that. Even if I put this here, I don't want to talk about I learn. That will be clear about that.